Just got finished listening to it. Now you're supposed to read through a stack of paper on a 10-minute break before you have to cross. You'll actually have reasonable time to prepare. The third of 4 levels here is counsel only. And let me tell you a quick story to illustrate why this exists. I had a rape case of an 8-year-old, and we gave over, as in my county, we traditionally have given over pretty broad discovery. I wouldn't call us an open discovery jurisdiction. Anybody here practice in Delaware County? Nobody is willing to admit it anyway. And we gave this over to local defense counsel, and his normal practice was he just had a secretary copy the whole discovery, package it, and give it to the guy. Well, it's a sex case. These were colposcope photographs of the 8-year-old girl's genitalia, and pictures of them ended up in my county jail. And the defendant was walking around showing these pictures to other inmates and making the comment, does this look like an 8-year-old epithet to you? This looks like a 30-year-old to me. And fortunately, we were able to use those statements, and he ended up being convicted. But the point is, it was clearly inappropriate to have that kind of photograph of 8-year-old genitalia floating around the jail. So and right now, most of you in most jurisdictions probably wouldn't get that, although there's a good argument that you need that in certain kinds of cases and other material like it to prepare your defense. So the third area is material that we give over but stamp it counsel only, which means that it's for you and your staff, your experts, people in your office. It is not to be copied. It's not to be disseminated. It's not going to the defendant, although I'm certain that defense lawyers will, during their consultation with their clients, talk about the nature of it. And anything that was certified originally by the prosecutor that the court said, you got to give that over in discovery, automatically becomes this, whether it's stamped or not. And then the final area, which is very limited, we do have a small category of inspection-only items. And you've got the list there, I think,
Yeah.
Ian.
Really what this came down to, and this was really the final evening of this, and this dealt more with the sexual assault cases. The sexual assault cases with minors, and this was basically children, victims under 13, or rights of inspection. And here's the rule: the right of inspection in cases of sexual assault. In cases of sexual assault, counsel, agents, employees, representatives, so that goes to our investigators, so on, shall have the right to inspect photographs, results of physical exams, so on. Hospital records not related to the information, indictment, or complaint are not subject to inspection or disclosure. Basically, it's everything dealing with that incident you'll get. They're not going to turn over everything from years before at that hospital, which we've never gotten anyway. Still doesn't limit us in our ability to subpoena the material and then file a motion or response to a motion to quash filed by a civil firm, typically what we would get. The statements of the child victim of sexual abuse under 13 was really, I think, kind of the last sticking point of that debate, and that really it was a tough issue. But with the agreement of inspection on that, and then let's describe what happens right before trial with all of that information.
Immediately before trial, anything that the prosecutor is certified that he has withheld or she has withheld, that material is subject to a review by the trial court. And just as right now during 16B1G time, defense is afforded an opportunity to participate in that in-camera review. This in-camera review also has defense counsel. That means that 7 days before trial, even if we have declined for reasons of security to disclose a witness statement, you're at least going to get to read it in judges' chambers. Now, unless the judge finds that we have abused our discretion, and the prosecutor has abused his or her discretion, you may not get a copy of that, but the point is you will see that, and you'll see it in advance of trial so that you'll know what's coming at you.
Now, we drew upon the models of the other states that practiced open discovery. And they all vary. I mean, in Florida, if you go to Florida, you're going to do depositions. You're going to go to certain other states. We took kind of little bits and pieces from all the different states. And so when you first hear it, it's definitely radically different. But in speaking with bar heads in other states, it was more kind of hype and fear than really was deserved. After 6 months, everybody kind of worked out and everything was fine, and you have free flow and exchange of evidence both ways. And so I think that's exactly what's going to happen here. I have no reason to believe anything different. The other side of this is what I talked about a minute ago, the reciprocity aspect of it. And the rule there, it'll be subsection D, if the defendant serves a written demand for discovery or any other pleading seeking the disclosure of evidence, there is a reciprocal duty of disclosure, and that arises without any further demand by the state. And so the defendant then has to provide copies or photographs or permit inspection to the following: lab reports, hospital reports, same thing as the rule would have now. Any evidence, this is new and this is drawn upon several of the other states, any evidence that tends to negate the guilt of the defendant or is material to punishment or tends to support an alibi. However, and this is clear, nothing in this rule shall be construed to require the defendant to disclose information that would tend to inculpate them. Investigative reports, except as provided by work product and so on, would have to be turned over. Investigative notes and any written or recorded statements by witnesses that the defendant intends to call in its case in chief or rebuttal, surrebuttal, would have to go over again, subject to privilege and confidentiality. So that's kind of the difference here, is that it's not, you can't just file discovery and expect that you're going to get, and that's the end of it. You've got to now, there would be a certain reciprocal obligation, and the sanctions, the regulation of discovery is that the court will have discretion to, if you don't comply on either side, to limit. And it was felt that, the goal was, again, to eliminate surprise, to make sure that all of the information is known. And so this was what was agreed upon by all parties, the public defender's offices, the various bar associations, the prosecutors association. Do you have any other comments on the rule itself? And then we'll talk about the process where it's going.
Yeah, a couple things. First of all, on the reciprocity, want to emphasize what Ian said. You still have the right to opt out of this by simply not filing for discovery. So that opt-out provision remains. Secondly, a lot of times, I shouldn't say a lot of times, but I have had cases in my county where on the fourth day of trial, defense counsel produces some evidence which, had I known of the evidence, I would have reconsidered my position in plea negotiations. Hopefully, reciprocity